As a personal injury attorney, people ask me all the time if I was in a car accident here in California and I was partially at fault, partially to blame for the accident, can I still recover damages? Can I still win a money settlement? The basic answer is yes. The rule in California is what we call comparative negligence or comparative fault. This means that you can still recover damages, but your settlement is reduced by the extent to which you were at fault. Let's consider an example. Let's say that you're jaywalking across the street. You're distracted because you're looking at your phone. It's nighttime. A car comes along speeding without its lights on and hits you. A jury looks at this case and says, you know what? Both of you were at fault. In fact, we think that each of you was 50% at fault for this accident. And let's say that your damages turn out to be $100,000. Well, instead of walking away with $100,000 in damages, you would walk away with just $50,000 because your settlement would be reduced by 50%. Now, the ideal lawsuit is one where it's clear that the other side is 100% at fault. But even if you're partly to blame, you may still be able to get a sizable settlement. And a good personal injury attorney can often convince the insurance company and the court that the other party is really to blame and that your fault is little, if any. If you were in a car accident, even if you were partly to blame, we invite you to call us here at Shouse Law Group at 855-JUSTICE. It's likely that we can still get you a substantial settlement.